Unit 4. Rulemaking, Quasi-Legislative, Power of Administrative Agencies, Delegated Legislation, Introduction. Delegated legislation is legislation made by a body or person to whom the Parliament has delegated its power to legislate. It refers to a binding law issued by a body subordinate to the Parliament. In Ethiopia, delegated legislation refers to directives and regulations issued by administrative agencies and the Council of Ministers, respectively. Delegated legislation tends to provide detailed legislative schemes setting out matters that are regarded as not necessary for the Parliament itself to approve by passage of primary legislation. Since legislation should preferably be made by the Parliament, and not delegated to non-parliamentary entities, delegated legislation is regarded, at best, a necessary evil that is only tolerated because of the growth and functions and requirements of a modern government. A more problematic issue is that delegated legislation might be regarded as a challenging concept regarding the separation of powers and that it is legislative in form and executive in source. This unit discusses the nature, definition, the challenge and justifications, the constitutional scope and procedures of a delegated legislation. Objective. At the end of this unit, students are expected to understand and enumerate the practical justifications for and theoretical objections against delegated legislation, discuss the scope or constitutional limit of delegating power by the legislator under the FDRE Constitution, indicate the forms of delegated legislation in Ethiopia, compare and contrast rule-making procedure in different countries, and summarize the common standards. Examine the practice with respect to rule-making procedure by agencies and the Council of Ministers in Ethiopia. 4.1 The nature and definition of delegated legislation. The term legislation refers to the process of making or enacting and repealing a positive law in written form by a branch of government constituted to perform this process, which is the legislature. The legislative organ of every country has the power to make laws on every matter concerning the lives of its citizens and the government subject to the limitations imposed by the Constitution. In England, where the doctrine of parliamentary sovereignty is propounded, Parliament as a matter of principle can enact or repeal legislation as it sees fit. Whether there is a clear limitation or not, the legislature is in charge of making laws in the form of primary legislation. Any other legislation that is subordinate or auxiliary to primary legislation is known as delegated, or sometimes ancillary, legislation. In short, delegated legislation means the exercise of legislative power by an agency that is subordinate to the legislature. This subordinate body acquires the power from the acts of the legislature. Power is transferred from the principal lawmaker to the lower body, which may be the executive, cabinet, council of minister, or a specific administrative agency, by the mechanism of delegation. Generally, delegation refers to the act of entrusting another authority or empowering another to act as an agent or representative. By the same token, delegation of legislative powers means the transfer of lawmaking authority by the legislature to the executive, or to an administrative agency. In line with the power granted to them by the legislature, administrative agencies can issue rules, regulations and directives, which have a legally binding effect. The study of rulemaking, delegated legislation, by the executive branch of government occupies a significant place in the administrative law due to its increasing growth, complexity and the dangers it poses to individual liberty and freedom. Scholars regard delegated legislation as a typical characteristic of administrative activity in public administration. One of the most significant developments of the present century is the growth in the legislative powers of the executive. Measured by volume, more legislation is produced by the executive government than by the legislature. The increase in quantity and quality of delegated legislation, if not supplanted by clear procedures and effective controlling mechanisms, may ultimately result in arbitrariness and abuse of power, which in turn leads to injustice and violation of liberty. That is why it is regarded by many as a necessary evil. It was considered a danger to the liberties of the people and it devised to place despotic powers in few hands. It was said that delegated legislation preserved the outward show of representative institutions while placing arbitrary and irresponsible power in new hands. However, in reality, the intricacies and complexities of modern government have proved beyond doubt that the delegation of legislative powers to administrative agencies is a compulsive necessity. In no democratic society committed to the establishment of a welfare state, the legislature monopolizes the legislative power. It will be futile for the legislature to solve the ever-increasing social and economic problems, unless it shares some of its powers with the executive and other administrative organs of the state. A statute may be inexact, incomplete, and unintelligible, and may even be misleading unless it is read with specific rules and regulations made thereunder. Delegated legislation also serves a technique to relieve pressure or legislature's time so that it can concentrate on principles and formulation of policies. After this, it has to leave technical and detailed matters which are necessary to fill the gaps in the primary legislation. Nowadays, administrative rulemaking has become a typical characteristic of the administrative law and administrative activity. The 20th century has been termed as the age of regulation due to the increasing number of instruments issued by the executive branch of government. Most of the legislations that govern the conduct of the individual come from administrative agencies, not from the legislature. How do you distinguish administrative actions from quasi-legislative actions? There is only a hazy borderline between legislation and administration, and it is difficult to show there exists a fundamental difference between the two. One common point of difference is that the legislative power is the power to lay down the law for people in general, whereas administrative power is the power to lay down the law for them, or apply the law to them in some particular situation. It is also a common principle of legislation that legislative aid should be public. One test of distinction may be that where the former is a process of performing particular acts or of making decisions involving the application of general rules to particular cases, the latter is the process of formulating a general rule of conduct without reference to particular cases and usually for future operation. Rule-making action of the administration partakes, with some exceptions, all the characteristics of a normal legislative action process. These may be generality, non-retroactivity, and a behavior which bases action on policy consideration and gives a right or a disability. In some cases, however, administrative rule-making action may be particularized, retroactive, and based on evidence. On the other hand, a quasi-judicial action is particularly based on the facts of the case and declares a pre-existing right. 4.2 The need for delegated legislation. Despite the ever-increasing volume of primary legislation, the complexities of governing a sophisticated society, and even a developing society, demands the delegation of some legislative functions to inferior bodies such as ministers and administrative agencies. Clearly, Parliament does not have time or resources to enact every single piece of legislation that is needed in the form of primary legislation, which can be fully debated and scrutinized in accordance with legislative procedures. The result is delegated legislation, legislation produced by an inferior body which nevertheless is the force of law. Tackling the complexities of modern administration in an efficient and efficient manner demands an atmosphere of complexity. Parliament has to follow strict legislative procedures to make a single law. Hence, it will be far from being flexible without delegating some of its powers to the executive. Can you try to identify impacts of retaining all legislative power by the lawmaker, Parliament? The complexities of modern administration are so baffling and intricate and bristle with details, urgencies, and difficulties. Therefore, to tackle these problems, an atmosphere of flexibility is needed. A parliament which sits for a limited period of time and which is required to observe strict legislative procedures will be far from being flexible without delegating some of its powers to the executive. Taking into account the above general justification, the following factors may be mentioned as reasons for the need for delegated legislation. A. Limitation on parliamentary time. Art. 58(2) of the FDRE Constitution reads, "The annual session of the House shall begin on Monday of the final week of the Ethiopian month of Meskrem and end on the 30th day of the Ethiopian month of Sin. The House may adjourn for 1 month of recess during its annual session as stated in Art. 58(2) of the Constitution, assuming that there is 1 month recess. For how many maximum days will the House of Representatives sit in Parliament? Then subtract 39 weekdays and multiply it by 8 working hours. Taking into consideration the average time necessary to make law, do you think the House of People's Representatives has sufficient time to provide all the laws in quantity and quality? It is said that even if today Parliament sits all the 365 days in a year and all the 24 hours, it may not give the quantity and quality of law, that which is required for the proper functioning of a modern government. Therefore, it is clear and self-evident that the main reason for delegation of legislative power is to relieve that pressure on parliamentary time.